Right, Mr. Marland.
Grateful, my Lord. My Lords, before the short adjournment, we were just looking at the Messier report behind tab 27 in volume 3, page 242, hard copy 267 electronic. And this was the report primarily into the Air Ontario incident in 1997. Date of the report is October 25th, 1997. And on page 242, you'll see section 5, additional data, which says this: there are 3 additional units in the Dash 8 fleet that have had broken damper rings. All 4 units, these 3 plus the Air Ontario shock strut, had excessive wear in the bore, that is the cylinder. Other units have worn beyond the component maintenance manual limits, but the damper ring had not broken. So the specific problem, and the specific problem in the Air Ontario case, is excessive wear of the cylinder. Now, that, as I said, is not a factor in this case. I don't believe that's at all in dispute, but if your Lordships need a reference for that, paragraph 68 of Mr. Fisher's witness statement, which is in bundle 4, tab 47, page 408, or electronically 438, makes that point. It's made in a number of other places as well. As I say, I don't believe that to be at all controversial. At paragraph 36 of our written case, I don't propose to go through this, but we do bullet point, as it were, all of the previous incidents with the references. And from that, you will see, as I said before the short adjournment, that you have an initiating cause which is either excessive wear to the cylinder or insufficient hydraulic fluid. In all of those cases, all of those...
Is this an initial cause of the loss of damping?
Yes.
Yes. And that's never, on these cases, the damper ring or the upper bearing? Never?
No.
No.
What happens is that there's an initial loss of damping for one of those 2 reasons. That then allows the hammering action between the seal carrier and the upper bearing, which then breaks off the lugs, which then, as you've seen what Mr. Hall accepted in cross-examination, the sequence is hammering, lugs go, then the damper ring goes. So yes. The damage is the effect.
Just help me with one bit of your written case, if you could.
Yes, absolutely.
Paragraph 99. This is about the entirety of the evidence about what Messier Dowty knew or should have known. And it's A. If you wouldn't mind just helping me on that.
Yes.
Looks to me to be diametrically opposite.
Yes, that might be infelicity. Again, it's
well,
almost...
infelicitous or inconsistent.
It is inconsistent. It may in part be because of the chicken and egg nature of this, that what you'll have is an initiating loss of damping. That destroys the parts. There is then a further loss of damping because the parts have been destroyed.
Well, that's another case. We've had a number now.
Well, again, the essential point is that the damage is an effect of something else in all of the previous incidences.
Well, the case that you're now advancing and you invite us to accept, was that put during the trial?
Well, in effect it was, because what one comes back to is you have the 4 possible causes that are derived from the Flight Safety Inspectorate report. The important point being that they're not mutually exclusive. So to take the example of fragmented damper ring, as you will see from the previous incidents, fragmentation of the damper ring in the previous incidences occurs because something else has happened to allow this hammering action. So whilst it was a possibility, and I put it no higher than that what one had for the first time in this case was a fragmentation or dislodgement of the damper ring with no initiating cause, ultimately what we say is none of the evidence supported that being the case. And that's where I say the confusion arises, because essentially what the Chief Justice appears to have done is to have stopped the inquiry at, I'm satisfied that the damper ring was fragmented. That's the end of my inquiry. What he hasn't done, which is critical given that these are not mutually exclusive, is say, having found that the damper ring in this case fragmented, why did it fragment? If it fragmented because of this hammering action, which was caused by an initiating event of which the only realistic contender in this case is insufficient hydraulic fluid, the claimants lose. Their case depends, and even this doesn't get them home for reasons I will develop, their case depends on these parts, as they put it, not being robust enough to withstand normal usage. In other words, these parts have fallen apart with no initiating hammering action, no initiating loss of damping. Because it's that, as we've seen, it's that initiating loss of damping, for one reason or another, that allows the hammering action to take place.
Let's fall down to the hydraulic fluid being insufficient. Why did they modify the design of the upper bearing and the damper ring in 1998?
They modified it, effectively, as Mr. Fisher says, to improve an already proven design. What you had...
That's not what Mr. Fisher said in evidence, is it?
It is what he said in evidence with respect, and I'll take you to a passage of his evidence where he reiterated that. What happens is that you have, as we see from the Air Ontario report, issues with excessive wear, which then which causes a loss of damping, which results in damage. Now, in order to try and mitigate that effect of excessive wear, which was the very specific reason that this was done for, they introduced this modified design. The root problem, which is not the case in this case, was excessive wear. And you can in fact see that in the engineering instruction that you were taken to. Well, in fact, perhaps if I pick up where Mr. Fisher dealt with it in evidence, which was in Bundle 5, at page, I believe, 887, which, behind tab 54, which electronically it's internal page 48 of the transcript.
I think it's page 921.
Yes, 921, my Lord, I'm grateful. Now, to put this in context, this is 2 pages on from the passages you were taken to by my learned friend this morning, concluding with Mr. Fisher reiterating the reason for the modification was to provide an improvement to already proven design. At the top of page 887, you see this. Mr. Roll, sorry, we're back in Plaintiff's Volume 3, Tab 3. This is the engineering instruction. That's the third one from the top. Reason for modification. The court, yes. So, Mr. Fisher, is that not the real reason for the redesign? As stated, yes. Now, the engineering instruction referred to is at... forgive me, I've lost it.
Might be 271.
I believe that's right, yes. 271, tab 34, volume 3. Grateful, no, actually. In fact, tab 33. page 269, is 294. 294 electronically. You see there the engineering instruction dated in August 97, and 3 lines down in the boxes section, you'll see a section entitled Reason for Modification. And the reason given, which Mr. Fisher in oral evidence has confirmed is the reason, to improve the support for the damper ring to prevent failure due to excessive wear. So, again, it's a response to an abnormal situation. It is nothing to do, critically, with we have a problem in normal use. It's that we have a problem which can arise, which is excessive wear to the cylinder. As part of the mitigation of that, we'll introduce this modification. Nothing to do with normal use, and nothing to do with the part not being robust enough to withstand normal use. It's to do with the fact that the parts are not robust enough to withstand being hammered, which is a different thing entirely.
Well, without being over simplistic, as I understand it, your case now is that the fracturing or fragmentation of the damper ring is the consequence of the accident rather than having any causative effect whatever. Was that in terms put to the Chief Justice on the trial? And if so, can you refer us to where it was put to him?
In express terms like that, I don't have a reference that I can take you to immediately.
Well,
but I say
would it not be necessary? I mean, if that's the elementary basis of your case, if the Chief Justice hasn't had an opportunity to confront that case, how can you say that the Court of Appeal was justified in overturning his decision?
Well, it was put to the witnesses in the sense that it was put to them that insufficient hydraulic fluid is an initiating event. You've seen the evidence that Mr. Hall gave about the sequence where he accepted the sequence. So it was there, it was out there, without...
But even so, if your case resolves to the proposition that the fragmentation of the damper ring is in no sense causative of, or could in any circumstances be causative of the accident, surely that case has to be put explicitly.
It's not that it's in no case, it's this, that in none of the previous incidents was it a cause, it was an effect. It was an effect of something else. And of those two something else's that the previous incidents reveal, one is excessive wear, not applicable in this case, and the other is insufficient hydraulic fluid.
Well, does that mean that you accept as a theoretical possibility that fragmentation of the damper ring could bring about an accident?
It could, which is why it was down as one of the possible causes. But what I say, as I said before the short adjournment, is that actually when all was said and done, there was not a single shred of evidence anywhere before the court that showed any instance of that happening without an initiating event. And the only relevant initiating event of the two which were known is insufficient hydraulic fluid.
What's the initiating event in the Air Ontario?
Excessive wear to the cylinder.
Yeah, so that would then cause loss of damping.
Yes, because what you have is the cylinder bore.
I don't need the technical explanation, just the headline.
Yes.
And so I'm just looking at the list in the agreed statement of facts and issues of the 4 causes for loss of damping,
Yes.
which doesn't include that.
No, because Air Ontario, we say, is not relevant. So we know that one thing that can be ruled out in this case, about the only thing that can be at the start of this case, is excessive wear to the cylinder.
Okay, so this is not loss of damping in theoretical terms. This is in this case.
In this case,
Yeah.
yes. Yes. So in Air Ontario, and indeed the problem that effectively was initiated in the needle roller case is you end up with a bore that's too wide, so the fluid flows around the outside. So you lose the damping as a result, in a nutshell.
This is all a little fresh to me, I'm afraid, but I'm getting there slowly. What is it on your argument causes the excessive wear to the cylinder?
In Air Ontario, we don't.
What is the risk against which the modification has been made? Answer, you say
Excessive wear.
excessive wear of the cylinder. Well, what causes that?
In two cases, the anti-needle, the needle roller, which is why that part was withdrawn.
On other aeroplanes?
On other airplanes.
What about this?
Then what one is left with is the one instance of Air Ontario where, as far as I'm aware, no cause has ever been attributed to the excessive wear.
Well, something's got to have gone wrong, if at least one assumes so.
Yes, but that something must have gone wrong, indeed. But that doesn't put it on our watch necessarily.
Well, wait a minute. Whatever it was that went wrong, you told your engineers to change the part in order to prevent it happening again.
Yes, and it didn't happen on this aircraft. It was not a relevant factor.
Oh, I see.
And again, it's not to prevent it happening, it's to try and mitigate the effects of it happening. Now, in this case, no mechanism has been posited or advanced whereby the damper ring becomes broken or dislodged without some initiating cause. But that's what the claimant's case relies on. And so it's probably convenient at this stage to just shortly deal with the burden of proof point. You were taken to the plea of contributory negligence in the defence. In fact, the relevant pleading in the defence is paragraph 2. So this is at tab 7, in its page 79, in the hard copy and 96 electronic. And not very civil procedure rules-ish, I know, but paragraph 2, the first defendant is unable to admit or deny paragraphs 6 to 23 of the statement of claim, and the plaintiff is required to prove the matters set out therein. That's the relevant pleading. The legal and evidential burden in respect of maintenance or fluid, I say, was on Bahamasair throughout. The legal and evidential burden in respect of what the root cause of the loss of damping in this case was on Bahamasair throughout. Now, that, I say, is derived, as you've seen in our written case, and I don't propose to go through these unless you want me to, is derived, first of all, from Donoghue and Stevenson, and is reiterated in Evans and Triplex safety glass, which your Lordships have at tab 13 of Authorities Bundle 2. That is perhaps just worth picking up very briefly. So that should be 111 in tab 111 in the electronic bundle, page 2385. In the hard copy, it picks up at 2327.
Sorry, bear me a moment.
It's Authorities Bundle 2, my lord. It's tab 13.
Page.
Well, if we start on the first page with the head note.
Thank you.
So the plaintiff bought a motor car fitted with a windscreen of the defendant's manufacturer. When the car was being used about a year after the date of purchase, the windscreen suddenly and for no apparent reason broke into many fragments and injured the occupants of the car. Held in the circumstance, the manufacturer is not liable for the following reasons: the lapse of time between purchase and occurrence, the possibility that the glass may have been strained when screwed into its frame, the opportunity for examination by the intermediate seller, and the breaking of the glass may have been caused by something other than a defect. Over the page, just to pick up a point that was made by the plaintiff in submissions, at the top of internal page 284, page 2328 in the hard copy, this was said: other evidence given shows this was not an isolated case, and the defendants admit that 150 windscreens have burst, mostly from impact with stones, but there were many cases to which they could not assign a reason. The glass was made to stand the stresses and minor shocks of road user, and the inference ought to be drawn that there was a defect. And then what was said in this case by Mr. Justice Porter, at internal page 286, hard copy page 2330, just over halfway down that page. It is true that, as Mr. McCaskey points out, in these cases he, i.e. as plaintiff, has not got to eliminate every possible element, but he has got to eliminate every probable element. And then ultimately, in that case, found that the plaintiff hadn't done so because of all the factors identified in the head note. Now, in respect of maintenance, I say that not only the legal burden, but the evidential burden must remain on the plaintiff in this case, for the simple reason that they are the only ones with the maintenance evidence. They have control of the documentary and witness evidence relating to maintenance. It's entirely in their hands. And indeed, as this case has shown, there were myriad problems with what was, or rather what was not disclosed in this regard. There's no evidence in terms of documents of Mr. Moss's relevant qualifications, no contemporaneous maintenance control manual as adverted to by the Court of Appeal. That was never produced. Certain other documents produced late, and so on and so forth. But the fact that it's peculiarly within their control to say what did or did not go on in terms of maintenance, I say is grounds for saying that the evidential burden, as well as the legal burden, remains on them. Now, the judge's approach to the burden of proof was, as the Court of Appeal observed at paragraph 31 of their judgment, for your reference, is at tab 14 in bundle 1, page 148, hard copy, 165 electronic. That's where the Court of Appeal said that, in effect, the judge had wrongly treated this as a case of res ipsa loquitur. Now, on the basis of the previous incidents, given that excessive wear to the cylinder can be ruled out, if res ipsa loquitur had any application in this case at all, it was to give rise to a presumption that there was insufficient hydraulic fluid, because that, from the previous instance, was the only known other initiating cause. The accident itself, as in the damage to the components, is entirely consistent with poor maintenance and inadequate fluid. Indeed, it's part of the claimant's case that this accident bears similarities, indeed in some cases identical issues, to the previous incidents. Now, the claimant's written case mischaracterises the evidence of Messier Dowty's witnesses with regard...
Just before you go to that, is
Yes.
it your case that the judge, in some way, proceeded on the basis of res ipsa?
Yes.
Where, please?
It's that he reversed the burden of proof.
Where, please?
Yes, it's in tab 12.
Mm-hmm.
And it's the way that he deals with the defendant's case at paragraph 52. It's page 121, hard copy.
Sorry, say the judge applied res ipsa at paragraph 52.
It's paragraph 52.
But, forgive me, well, that's right, let's look at it.
Yes, in my judgment, the defendant has not proven that the plaintiff was negligent or that its negligence caused the accident. In my judgment, the accident was caused because. That, we say, and the Court of Appeal agrees, that the judge has put the burden of, if you like, proving maintenance on the defendant, where the burden properly lay, because this is a case, of course, where there's no direct evidence as to this part fragmenting effectively spontaneously, because the damage to the parts is evidentially neutral at its highest, because it's entirely consistent with previous incidents where there's been an initiating cause of loss of fluid. So it's a case which the claimant has to prove by effectively circumstantial evidence. And in those circumstances, particularly in those circumstances, part of proving their case is eliminating other possibilities. And that's what they failed to do. Now, the judge...
Just a minute, hang on. Res ipsa normally. And people are always pleading it.
Yes.
But, insofar as it works, it's usual, the usual syllogism is, isn't it? This accident could not have happened without negligence, therefore the inference is that there was negligence. Now, in the present case, the judge's finding as to negligence is, isn't it, that you were under a duty to tell operators that you had modified the strut.
Well, it's more...
What you're saying, what you're concentrating on is not the finding of negligence, but the finding of causation.
Well,
By the sound of it.
It's not. It's this. What the judge says, and this is at paragraph 52,
Yes,
is...
by then you're into contrib. He's already found your negligence. Right back at
29.
27, 28, 29, and so on.
Yes, but then you look at what he found that we had an obligation to warn the plaintiff of, which is that the danger that the design of the upper bearing and dampering may not be robust enough to withstand the recommended usage.
Yeah.
That is not established whatsoever anywhere in the judgment or anywhere on the evidence, because insofar as it depends on, for example, previous incidents and so on and so forth, those are outside the recommended usage. As soon as you get this damage being caused by the hammering interaction between the upper bearing and the seal carrier, it is not anything to do with its recommended usage. It's an abnormal situation that the part can't withstand.
Where do we see all this technical expert material reflected in the documentation placed before the court?
In terms of what?
Well, you're just talking about the initiating event, the abnormal usage, the damage to the part which enables the banging process to go on.
Before the short adjournment, I took you to tab 81, and indeed to the extract from Mr. Fisher's evidence and from Mr. Moss's evidence, which all talk about the effectively benign contact in normal usage between these two components, the seal carrier and the upper bearing. So in normal usage, you have what was referred to as non-catastrophic soft contact. What's happened in the previous cases, where you have an initiating loss of damping, is that you then get this hard hammering contact, which causes the damage.
Should we have a look, though, at what's Messier Dowty's own view of the Air Ontario causation?
Well, I thought we'd done that. It's excessive wear, isn't it?
The end paragraph says the initiating event cannot be determined from these observations.
The initiating event of the excessive wear.
And it goes back to the possibility that it's caused by a broken ring or a damaged upper bearing.
Yes, and again, don't forget that Air Ontario was effectively the very first. Things move on from them. Because if you recall, one of the issues with Air Ontario that my learned friend's very keen on is the suggestion that there was approximately the right amount of hydraulic fluid. Now, my learned friend's very keen to say approximately right amount of hydraulic fluid equals right amount of hydraulic fluid. Mr. Fisher was very careful to say two things. First of all, approximately. Secondly, that given that this occurred at a time when the significance of hydraulic fluid was not at that stage fully appreciated, effectively he didn't know whether approximately the right amount of hydraulic fluid did mean the right amount of hydraulic fluid. So this is part of the trouble with Air Ontario. Air Ontario is very early days, and it's 7 or so years before we get to this accident. The important thing I say by the time we get to this accident in terms of what was known is what's reflected in all operators message 794 and what's reflected in the airworthiness directive that effectively mirrors that came out a month after the servicing. Yep. All operators message 794 represents in my submission what was known from all of the previous incidents by Messier, Dowty, by Bombardier, and by extension, given that the Airworthiness Directive effectively mirrored that language, by Transport Canada.
So it is causation, isn't it? I mean, am I right that the reason for the modification was effectively Air Ontario?
Air Ontario as part of a suite of, if you like, excessive wear cases.
Yeah.
Because as we've seen from the report DS 650, Air Ontario at that stage is treated as, if you like, a suite, part of a suite of these incidents. All of them are excessive wear, but in 2 cases, not on Air Ontario. Messier Dowty were able to go, this is caused by this needle roller. So we know now what the cause in 2 of these incidents is of the excessive wear. So our response is let's get rid of the offending part, which they do. The needle roller is removed under a mandatory service bulletin within a certain period of time, because having identified that that's, if you like, the root cause, unsurprisingly what Messier Dowty do is go, right, let's get rid of that root cause. Air Ontario, the cause, as far as I can see on the documents, the cause of the excessive wear to the cylinder is not identified. But it could be effectively either manufacturing or maintenance or something else. Air Ontario does not point towards product liability, if you like.
Well, can you just go back? I'm sorry to harp on, because I want to try and follow your argument,
yeah.
New as it is. Page 885 is, I think, Mr. Fisher's evidence.
Yeah.
Tab 54. We were taken this morning to the passage which begins at line 8. Suggestion, having encountered particularly the Air Ontario scenario, recognising that even with sufficient fluid you were getting problems resulting as a result of damage to the upper bearing and damage to the damper ring, modified in order to prevent it. I'm so sorry, Mr. Marlin.
No, that's quite all right, my lord. I was looking for another reference, which was where, essentially, which is where, as I mentioned a moment ago, Mr. Fisher takes issue with the suggestion that Air Ontario is a situation where there is sufficient hydraulic fluid. That's back at page 870.
Yeah. Chief, is that, or is that in...
No, that's in cross-examination. And so it's internal page 31. So at line 20, let's deal with the penultimate sentence. The shock struck from Air Ontario having the correct amount of hydraulic fluid. So if we take this factual scenario from Air Ontario, you have the correct answer, approximate.
Yes, I thought.
Approximately. And and he explains elsewhere, I believe it's in his witness statement, 873, sorry, it is in the examination. So he says this, as Air Ontario was the first event of over-centering torque link, pausing there, you may recall the two other incidents at this stage were discovered on shop visits. Air Ontario was the first one where there'd actually been an over-centering event. The importance of the fluid level was not immediately recognised. So it is unsafe, my submission, to conclude that Mr. Fisher's evidence accepted that Air Ontario involved the correct amount of fluid. He's cautious about that, and in my submission, his rights to be.
Mr. Marland, you said a moment ago that there was no evidence to support the Chief Justice's conclusion that the upper bearing and ring were inadequate.
To withstand normal, or their recommended usage.
That it was that you were referring to paragraph 52 of the Court of Appeal, where it's expressed as, 52 of the Chief Justice's judgment, where it's expressed that the defendant knew that there was a risk that they were inadequate for recommended cycles.
Yes, it's paragraph 29 in particular, which, if you recall, he basically leaps straight in to they had an obligation to warn.
Well, what about the evidence of Mr. Hall and Mr. Jones?
Yes. Mr. Hall, I took you to the passage of Mr. Hall's evidence where he accepted the sequence. Now, in respect of Mr. Jones's evidence, which is what the judge relied on in particular, Mr. Jones failed. We deal with this, by the way, at paragraph 59 following of our written case. The critical flaw in Mr. Jones's approach is to fail to consider distinction between normal contact and abnormal hammering contact. So if you look at his report in bundle 4, and it's tab 49, and it's page 492. It's 522 in the electronic. This is in a section 3 of his report, which is discussion.
Yes.
So 492, and again about halfway down the page, third paragraph down the page, the upper bearing exhibited wear and damage due to repeated contact with the seal carrier. This repeated contact that occurred every time the landing gear extended resulted in fracture of the lower ears on the bearing that act as a mechanical stop against the seal carrier and as lower lands for the damper ring. The damage on all the upper bearings inspected, as well as those in the documents reviewed in preparation for this report, indicate that the upper bearing was not sufficiently robust to sustain the contact loads associated with stopping the strut during extension. The lack of robustness resulted in ear fracture and the damper ring escaping from the upper bearing and eventual overextension of the strut. Now that's the claimant's case encapsulated. Now the problem with that, as I say, is there is no recognition whatsoever of the fact that in normal usage there isn't that kind of violent contact. The documents reviewed that he referred to are set out in page 497 at the end of his report in the appendix. In essence, you can see that it's Messier Dowty reports the report into this accident The airworthiness directive.
Sorry, you're on page 497.
497, yes,
Yeah.
which is 527 electronically. I do apologise, Mark. Essentially, Mr. Jones is referring to the reports of this incident and the previous incident. But each and every one of those previous incidents, whether involving excessive wear to the cylinder or insufficient hydraulic fluid, involved abnormal hammering. The contact between the seal bearer and the seal carrier and upper bearing was violent because there had been this initial loss of damping, and no recognition of that at all in Mr. Jones's report.
And we shall therefore see him challenged on that basis somewhere, shall we?
Well, what you see is he's challenged on why he effectively didn't consider it.
Simon, I'm sorry. What's the answer to my direct question? Shall we see him challenged on the basis that you are now explaining to us?
Well, yes, because you see him challenged on
Where?
why he hasn't considered this. Well, if perhaps
See, if you're right, on page 492,
Yes.
his core proposition, which is that the thing wasn't strong enough,
Yes.
is faulty because he hasn't allowed for the fact that you don't get the impact on the seal and so on, unless there's something else wrong.
Yes.
Right, well now, where do we see that explained or put to him so that the judge can
Yes.
consider it?
If you
If it's
look
there,
in
that's
volume
fine.
5,
Please, thank you.
at tab 54,
Yep.
page 899, and the hard copy.
Mrs. Jones, is it?
Yes. Oh, no, I do apologise.
I think it is.
Fisher. This is Fisher. I'm sorry, I do have completely the wrong reference. You're
Okay.
absolutely right.
While you're looking for that, presumably somewhere your expert, Mr. Langston, advanced the proposition that you're now explaining to us. Did he, to the judge?
Well,
Perhaps-
my lord, I'd
perhaps-
say this
perhaps-
proposition
perhaps someone sitting next to you
this
would find
proposition
that.
follows inexorably from the document.
That's not good enough, Mr. Mile. I want to see where it was ventilated at the trial. Since it clearly hasn't been ventilated before the Court of Appeal.
Well, Lord, I'll try and find that reference.
Okay,
if I
well,
can,
take your
please,
time.
'cause I'm
Let
having
us have it.
a bundle
if you will.
problem.
Otherwise, I'm
I will.
interrupting you unnecessarily. Thank you.
Yeah, I apologise. I can't
That's
lay
all right.
my hand on it immediately. But again, as I say, it follows inexorably from the reports of the previous instance. It follows from the fact that insufficient hydraulic fluid is listed as a possible cause of this incident, because it's not insufficient hydraulic fluid and then the shock strut overextends. The sequence, as accepted by Mr. Hall, is, and as you've seen in the document at tab 81, is insufficient hydraulic fluid allows, or loss of damping, allows violent contact, causes damage. And that's why it's accepted, by the way, by not only my learned friend, but by her witnesses as well, that the damage is consistent with insufficient hydraulic fluid, because that is the effect of what happens when you get insufficient hydraulic fluid. Now, neither Mr. Jones...
Forgive me, Mr. Warren. I asked you about Hall and Jones.
Yes.
You dealt with, well, you referred us to some passages in Mr. Jones. What about Mr. Hall? We find in Mr. Hall's expert,
Mr.
Hall's
Hall,
expert report that he says this at it's 448, 472. This ongoing wear occurring internally in the shock strut and unknown to the Bahamas personnel was the result of a design deficiency that allowed the damper ring and upper bearing as a unit to fail to operate in the manner that Messier Dowty intended, designed and expected.
yes. That's what he said, but as I say, there's no supporting evidence.
No, but again, let's see where it was challenged, please.
Well,
Because you see, your proposition is that the judge had no proper basis for a finding, which was precisely the assertion made by two experts. If it was challenged, that's fine, perhaps. If it wasn't, it may be rather different.
Well, again, I took you this morning to Mr. Hall accepting the sequence
Yes,
being
I've seen that.
the sequence of damage.
That doesn't explain, if I may say so. Well, there it is. You say that's enough, do you?
Well, I say that's enough because I say that you have to read it in conjunction with the fact that it's accepted throughout by the claimant, who, as I say, bears the burden of proof, that the damage is consistent with insufficient hydraulic fluid. It's accepted that it's an effect of insufficient hydraulic fluid. That's accepted in a number of places. I'll take you to those. But that is clear in my
Well, the
submission.
damper obviously isn't going to work if you haven't got enough hydraulic fluid in it. Even we can see that.
Well, absolutely. But then it's what happens as a result of insufficient hydraulic fluid. And what happens is these pieces get hammered to death,
Sure.
in a nutshell. And that's why I say the damage itself is evidentially neutral at best for the claimant, because that, certainly if one looks at the previous incidents, is nothing more than an indication of insufficient hydraulic fluid. It's not an indication that these parts are not robust enough to withstand normal usage.
I can see that at the trial, written submissions were put in. Have we got them? At the end of the hearing?
There were written submissions put in. They're not in the bundles.
Just wanted to see where this part of your case featured in them.
Yes,
A marked copy showing where that's...
I will endeavour to obtain
Thank
a copy. So, essentially, to encapsulate, as we say in our written case, that four essentially pieces of evidence that we relied upon by the claimant, which were the previous incidents, the fact that they themselves on their fleet had, including this gear, 3 instances out of 4 landing gears of fragmented damper rings. Mr. Jones's report, essentially, and the fact that there was an improvement. Now, the design improvement point, as I say, that is to address a different issue. That does not raise the bar on Messier Doughty's duty of care, simply because they say, well, actually, we can make a better part. The question is whether they had a duty to guard against what that part was introduced for, first of all, and secondly, what relevance, if any, it has to this case, to which the answer is none, because as the Court of Appeal observed, the fact that you bring out a new improved design, a new Coca-Cola recipe, doesn't mean that there was something deficient in the sense of negligent about the design of the old one.
No, by itself it clearly doesn't. If you've got a couple of experts saying there is something wrong with your previous Coca-Cola, then it might.
Well, yes.
The judge might be justified in concluding that that's the reason.
Save that the experts, as I say, in failing to distinguish between this abnormal contact,
Yeah, well,
which is what all all the other evidence points to. All the other evidence.
Okay.
So, yes, that on its own doesn't. There is then the question of whether the claimant did enough to eliminate insufficient hydraulic fluid, or, if you like, inadequate maintenance, as a contender in this case. Now, the starting point in that regard, I say, is the report of Mr. Langston, which is at volume 4. Tab 50. And in large part, Mr. Langston is not really challenged in cross-examination on this report, save with regard to the extension checks to be performed after the various blown tyre incidents, and as to his take on daily checks. Now, just for your Lordship's reference, I don't propose to go through it in the limited time we have. Mr. Langston's cross-examination is at 5:54, 9:12 to 9:33, or electronically 9:46 to 9:67. Now, unlike the claimant's expert...
We can look at it later, Mr. Martin, but somewhere in this is presumably Mr. Langston's explanation of the point that you've been explaining to us, is it?
Well, Mr. Langston dealt with maintenance.
Oh, I see. All right.
Yes.
Come.
Now, unlike the claimant's experts, Mr. Langston actually does have experience of Dash 8 aircraft, and he was a licensed Dash 8 engineer. Mr. Jones, for the record, confirms that he's never previously looked at this type of aircraft or this landing gear. That's at page 861 of the cross-examination transcript, 554, 895 electronically. So in terms of Mr. Langston's report, we start with his observations about Mr. Moss's qualifications to perform the work, which is at 510, at 540 electronically. And you'll see he deals halfway down the page, item 2, witness statement of Winslow Basil Moss with exhibits. The first issue is the licence itself, because the only licence ever produced by the claimant expressly does not show a type rating for this aircraft. That licence, or the only one that was ever produced in evidence, is at tab 80, which is in bundle 7, and it's page 1427 hard copy, 1469 electronic. Now, this is a licence that was issued in September 2006, so some months after the work that Mr. Moss says he did. And you'll see there, although the typeface is quite bad, there is a section at the bottom, type ratings, just above Mr. Moss's photograph. The Dash 8 does not feature. No evidence was ever produced of the required refresher training, and the general approach to licensing is also evidenced in my submission by the Flight Safety Inspectorate's observations in their letter fairly shortly after the accident, which is in bundle 2 at tab 19, page 208 to 210, so that's 229 to 231 electronically. Now, you may have seen there's some controversy about what was and wasn't produced to Flight Safety Inspectorate, but there appears to be no answer to what's found on the last page of that letter, which is warning notice of failure to renew licence, which lists 8 separate instances where Mr. Moss has allowed his licence to expire and effectively has to be chased by the authority to renew it. And in some cases, he's unlicensed for some months.
Could you help me as to which of your grounds of appeal to the Court of Appeal this fell under?
Yes, it was...
Because the judge found that he did have the necessary qualifications and licence, didn't he?
Yes, well, the judge found that there was a failure to adequately record by Bahamasair.
The evidence does not support the proposition that he didn't have the qualifications, he had the necessary training, etc.,
yes,
and at all times the necessary licence. That's the finding. So where is your ground of appeal?
The ground of appeal was ground... Yes, the learned judge failed to appreciate, this is ground 9 amended, which is reflected on page 141 of the Court of Appeal judgment. It's at paragraph 13 of their judgment as they run through the grounds of appeal.
So it's an oblique.
The learned judge failed to appreciate and or have any proper regard to the fact the respondent failed to ensure its personnel carried out service and work on the subject aircraft were duly certified to carry out such service and work.
So that's an oblique reference to this, is it?
Well, it is, because it must proceed on the assumption that they weren't duly certified
Right.
to carry out this work.
Okay.
That's a challenge. You'd say that's a challenge to the finding that they were.
Yeah.
I see.
My Lords, there's then the evidence that Mr. Moss says that he personally performed the maintenance, and indeed that's what the judge found, that he did personally perform the maintenance, notwithstanding that that's not what the maintenance records report to show. Now, back to Mr. Langston's report, what he says at page 511, this is tab 50.
Sorry, we're going to...
Langston.
So yes, it's volume 4, my lord, tab 50,
Yep.
page 511 hard copy, 541 electronic. He deals there with the Bahamas Air Maintenance Control Manual. Now, of course, this was the document that wasn't produced, as the Court of Appeal noted. He said it should not allow a mechanical supervisor to be able to perform critical repairs on landing gear and clear inspect their own work. And then he notes that they apparently discarded the written maintenance programme in effect at the time. And indeed, it shouldn't. The landing gear repair was or should have been what's called a required inspection item. Now, a useful definition of RIR is actually defined in the Bahamas Civil Aviation Safety Regulations, but the definition is in effect reproduced in the version of the Maintenance Control Manual that Bahamasair did actually produce, which is at volume 7, tab 67, and it's page 1259, 1302 electronically. And it's under 18.1. Item 2 under A, General. BASR schedule, and for your note, that the schedule reference in the regulation itself is actually 5.005A 7 requires identification of items which, if not performed properly, or if improper parts or material is used, would endanger the safety of flight. That's a required inspection item. Now, in my submission, self-evidently, landing gear, as Mr. Langston says, should fall within that definition. Now, true it is that this version of the Maintenance Control Manual postdates the incident, but the regulations it refers to don't. They're 2001 regulations. Now, there was additionally a suggestion that in the Bahamasair Maintenance Control Manual, landing gear only became a required inspection item after this incident. We simply don't know. But even if this is true, my lords, given the failure to produce it, we just don't know, that in itself, in my submission, would be evidence of a sloppy maintenance regime. Because self-evidently, on that definition, landing gear would always fall within that. It's clearly a safety-critical component of a commercial passenger aircraft. So the position is this, that as Mr. Langston observes, the Bahamas, unsurprisingly, like every other competent aviation regulator, do not allow mechanics to mark their own homework on critical repairs. Mr. Moss said in evidence, and accepted by the judge, that he'd done these repairs. Not only that that's what he did, but he said that that was company policy.
Sorry, what was company policy?
That effectively he could sign off on his own work. Now, the judge did accept at paragraph 46 of his judgment that the work was not properly checked. Now that itself is evidence, I say, of a lax maintenance regime. Now, what this goes to is the continuation sheets which supposedly record the work which was done. Those are the sheets that you will find at volume 7, tab 77. Which is the documentary record. Is the documentary record of the 19th of May work that was done. And the point was made, and Mr. Moss was cross-examined quite extensively on this, that you'll see on these pages, this page starts at page 1329 in the hard copy, that you have a series of boxes, the defect work required, the action taken, then mechanic's signature and signature authorising date. And then at the end of each page, supervisor's clearance signature. Mr. Moss, as BAH4, has effectively signed as supervisor all the way throughout. Whereas in fact, he tells us that what he was the person doing the work, and that effectively the signature in the mechanics box was an apprentice, with one exception. In some of the boxes, if you turn on through the worksheets, you will see a different mechanic has initialed some of the boxes with the stamp BAH 30. That is a mechanic carrying out, we are told by Mr. Moss, avionics work, which Mr. Moss is not qualified to do. Short point to be made, if he's not qualified to do it, he's not qualified to sign off on it as a supervisor. That again follows from the regulations.
What was the state of the evidence on this? I mean, the judge found, the Chief Justice found, that the evidence supported the fact the work done by Mr. Moss was not properly cross-checked. But are you saying Mr. Moss didn't do the work at all?
No, I'm saying that we have to accept that evidence. This is a finding of primary fact that Mr. Moss did the work. What I'm saying is that if Mr. Moss did the work and it was not signed off as a required inspection item, or was not in the manual as a required inspection item at that time, that is evidence that the maintenance regime was substandard. Indeed, I go further than that, as we say in our written case, it's so substandard it's unlawful. Now that is important, bearing in mind that this is a case dealing with circumstantial evidence. This informs the court when it's evaluating the competing possibilities in this case, of the possibilities that we started with. The court asks itself, can I safely conclude that the claimant has proved to me that, if you like, sloppy maintenance, insufficient hydraulic fluid, what have you, can be eliminated? I say, no, it can't, because you take into account the fact that the maintenance regime is lax. And even if you accept that Mr. Moss did the work, there is no evidence that he did it properly, because it wasn't signed off.
And which ground of appeal is this?
Well, it goes to, it's one to do with record keeping.
Did he claim to have done it properly?
Well, that must be the inference. He certainly didn't admit to doing it improperly.
No. Well, if he either by inference or otherwise claimed to have done it properly, and there wasn't sufficient evidence to create a question in the judge's mind, surely it's open to the judge to find that he did do it properly.
But that's an evaluation exercise.
Absolutely. Well, that's what a judge is there for.
It is indeed. But what I say is that as part of that evaluation exercise, the penumbra of background has to be taken into account. And the judge has found, amongst other things, that there's not proper record keeping. Now, the problem is that the judge, and indeed the Court of Appeal, because we say that this is where the Court of Appeal were perhaps overly dismissive of these other grounds of appeal, what they have done is effectively say, well, this doesn't provide direct evidence of the cause of the accident, which is true, it doesn't. But what it does do is colour the scene. When you're saying, I'm evaluating some possibilities as to what might have caused this accident, one possibility is that this wasn't maintained properly. What I say is that the court should, and the Chief Justice did not sufficiently take into account the fact that there was myriad evidence of substandard, unlawful practices in the maintenance regime at Bahamasair. Now, going back to what I said at the beginning about the importance of certification and the importance of complying with regulations in a heavily regulated industry, that, in my submission, is persuasive evidence that should mean that the court cannot be satisfied, whatever Mr. Moss thinks he did, the court cannot be satisfied that Bahamasair did the work properly, that they have eliminated...
So that wasn't a finding that was open to the judge?
I say that it was a finding that the evidence didn't support, that I say that he failed to take these elements into account properly when dismissing it as non-causative.
And that vitiates his finding.
Because, well, it does.
Well, unless it does, it's no help to you, is it?
Yeah, well, absolutely. It does, my lord, because if
Yeah, no, all right, I've got...
If this can't be eliminated, the claimant fails to prove their case.
I see.
It is the short point.
Yeah.
And I say it just can't be eliminated when you step back and evaluate the evidence as a whole. Part and parcel of that, just other examples, hopefully quickly, there is the mandatory check which should have been carried out after this work, which Messier Dowty maintain wasn't. Now, there are, in the continuation sheets, there are a couple of entries of note here. If you go back to its tab 77, in Bundle 7, and at page 1335, hard copy, 1378 electronically. I'm afraid the numberings have been a little obliterated by the binder, but the third entry down on that page should commence service shock strut as per Chapter 12 servicing 12.10.32. And then action taken, shock strut serviced as per maintenance manual, Chapter 12.10.32, pages 11 and 12. Now the reference to page 11 and 12 is important, we'll come back to that. Further down the page, the last two items there, carry out functional test of landing gear, extension, etc. And then 29, lower the aircraft off jacks. So whatever the check at 28 is, it was a test that's performed while the aircraft is still jacked up undergoing maintenance. It hasn't gone anywhere. Now, what is said by Mr. Langston about that is at page 509, 539 electronically. That's tab 50 in volume 4. Deals with this at his paragraphs D, E, F and G. And the critical one is F. It's over the page where he says, I emphasise this because this check is not the as soon as possible after 5 landings do the extension check of the main landing gear shock strut. These checks are 2 separate mandatory inspections. Now, what was initially said in the written witness evidence by Mr. Moss and Mr. Cooper is that the Flight Safety Inspectorate report was wrong when it said that an extension check was not carried out, by reference to this item 28. But it is clear that this is not the check referred to, and it's not the check referred to as mandatory in the maintenance manual, because if we look at 12.10.32, you recall that was the item under which it was said that this work was carried out. 12.10.32 is at bundle 7, tab 59. 1167. If you look in the bottom right-hand corner of the internal numbering, you'll recall the reference to pages 11 and 12. What you see is page 11 it starts on, and then beginning about halfway down the page, method 1, replenish the hydraulic fluid with the hydraulic servicing unit. Continues over the page on page 12. There are 22 steps set out. Critically, on page 13, not referred to in the continuation sheets, as soon as possible after 5 landings, do the extension check of the main landing gear shock strut. That wasn't done. And just for completeness, on page 13, there's an alternative method which also ends with the same test. And the effect of Mr. Langston's evidence is, well, here's something else that just wasn't done. Now, quite clearly, item 28 didn't refer to that. So Bahamasair changed tacks, and they claim that the check after 5 flights was the same as the check referred to in the so-called daily checks. Now, quite apart from the fact that having to change tack is reflective of an inadequate maintenance regime, because it's clear that they don't quite know what's going on, it's also wrong, which was confirmed by Mr. Moss himself, in spite of my learned friend's attempted interruptions in his evidence at this point. Mr. Moss, this is at tab 53 in bundle 5, page 741. I'm afraid I'm having a bundle malfunction here, so bear with me.
Mr. Moss.
This is Mr. Moss,
Yes.
and and starting at line 18, where it says, now look at item 24 on that document. That document...
Sorry, page
do apologise, 741.
741. My fault. Thank you very much.
Now, it says at line 18, it says, now look at item 24 on that document being the daily check. It says, check nose and main landing gear for obvious damage, leaks and correct strut extension. Now, with that type of check, assuming that it's done, would that be the same kind of check that one would carry out in accordance with item 23 of the aircraft maintenance manual that we just referred to? That's the 12.10.32 check. No, it's not the same thing, no. So, claimant's own witness confirms it's not the same check, in spite of attempts to suggest otherwise by Bahamasair. Langston's not properly challenged on this, and he reiterated that it was indeed a different check. Now, skipping forward because I'm conscious of the time, in Mr. Langston's report, again, he notes, he says 13 instances of improper maintenance practices in the continuation sheets. The reference for that is page 511 behind tab 50, and it's paragraph 3. He wasn't, as far as I can see, challenged on that. He audited the aircraft records for both of the Dash 8301s, BFN and BFO. His conclusions as to the state of those records, i.e. manifestly inadequate, are at page 511 and 512, again, not challenged. So all of his evidence, unchallenged, points to a defective or inadequate maintenance regime.
I'm sorry, elementary question. If the judge found and was entitled to find in all the circumstances that an appropriate amount of fluid had been inserted by Mr. Moss during the service, was it any part of your case that that level, that the hydraulic fluid then inserted wouldn't have been enough for safety purposes on the 20th of April 2007?
It's that it very well couldn't have been, because Mr. Fisher says it requires regular servicing. You may recall what was said in All Operators Message 794. Essentially, and it's probably an utterly imperfect analogy, it's like the oil in the car. It doesn't matter that you do it on the MOT. Over time, as you have seen from AOM 794, fluid is lost. Mr. Fisher said that effectively it needs regular topping up. Now, one thing we do know, this is in relation to the daily checks, because of course the inadequate maintenance doesn't just go to what was or wasn't done on the 19th of May 2006, it goes to what was or wasn't done between the 19th of May and the 2007 accident, nearly a year later. Nowhere, now, first of all, there was some dispute as to whether the daily checks were performed daily. Mr. Cooper gave evidence there were. One of the issues was, of course, that nothing like a complete set of daily checks was before the court. But be that as it may, in none of the daily checks that were produced is there any evidence of either fluid or nitrogen being introduced to the gear between May and April. So
were Bahamasair saying, well, we did make checks between May 06 and April 07?
Yes, essentially they relied on the daily checks, and I'll show you what they relied on. In the daily checks, whether or not daily, which are at tab 78 in bundle 7. What they relied on, and you see this is what was referred to in that passage of cross-examination by Mr. Moss, of Mr. Moss, I apologise. If you turn to page 1341 in the behind tab 78, again you'll see this is it's a pro forma document. It's a numbered checklist. What they rely on is item 24, which is why Mr. Moss has been cross-examined as to whether item 24 was the same as the check after 5 flights. And he...
What page are we on, I'm sorry?
Oh, sorry, 1341,
Thank you.
in the hard copy. It's
Yes.
item 24 on that numbered list. It's 1384 on the electronic, I understand.
Yes.
So Bahamasair's case is essentially, well, there you go, we did that, that's good enough. No evidence, by the way, no one who actually performed the daily checks called as a witness. Mr. Cooper didn't do daily checks, Mr. Moss didn't do the daily checks. They were done, Mr. Moss's evidence was to the effect that they were done by the night shift. But that's what Bahamasair essentially relied on.
Thank you.
And say, well, because you've got that box ticked, you can be satisfied that there was enough fluid. Now, again, conscious that time is short, my learned friend needs time to respond.
Well, you have 7 minutes left.
Yes, I've just seen that. For the claimant's case to succeed, it has to be shown, in my submission, that the parts were damaged without an initiating loss of damping leading to hammering contact. So, along the way, in order to reach that conclusion, the court would have to have concluded that Messier Dowty failed to recognise that these parts were inadequate for their recommended usage. Notwithstanding that one must suppose that in order to give this part a lifespan of 30,000 cycles between overhaul, one must assume that's not a figure just plucked from the air. Bombardier, as the overall type certificate holder for this aircraft type, missed this. Transport Canada, as the design authority who has to approve these parts for use, missed it. Not only initially when the parts were first promulgated, but subsequently. That Bahamasair suffered a condition not previously seen in any of the previous instances, all of which have this initiating cause. And not only does Bahamasair suffer it, they suffer it 3 times, because 3 out of 4 of their gear sets have the problem of broken parts. Now, against that is the possibility, never eliminated, we say, that there is insufficient fluid, the only other possibility being that there is some other initiating event which no one has been able to identify. If it's insufficient fluid, it would mean that the damage observed on the Bahamasair fleet, the 3 instances of gear damage that they have, are entirely consistent in both cause and effect with the previous incidents where insufficient fluid was the problem rather than excessive wear to the cylinder. It would also make it, in my submission, wholly unremarkable that Bahamasair has 3 out of 4 of their sets of gear damaged, because one can assume that the same, if you like, issues with maintenance are going to apply across the fleet of a single operator, because otherwise, effectively, they've lost the lottery 3 times. Mr. Fisher gives the figures for the worldwide fleet in his witness statement, which, again, is evidence which I say should have been taken into account, which wasn't. What Mr. Fisher says, if if I can find. Thank you. Historical data. This is at 413 behind tab 47 in bundle 4. At 443 electronically. Paragraph 98.
I'm sorry, bear with me a minute, please. 47, the hard copy page.
413, my lord.
Thank you very much.
And halfway down you see historical data as a section.
Thank you.
And he says this: as of February 2013, there were 568 Dash 8 aircraft in service with 96 operators, all of which were manufactured with the same basic design of landing gear. As of that date, this fleet had accumulated 21 million plus hours of operations and 26 million plus flight cycles. Bearing in mind, of course, as he says, 2 gear per aircraft. So 52 million cycles. As such, the 6 pre-incident failures would be statistically insignificant, he says. But leaving that aside, bearing in mind that the 6 other incidents all have this initiating cause, either excessive wear or insufficient fluid. For Bahamasair to have a condition which is neither of those, not once, but 3 times, would, as I say, amount to losing the lottery 3 times. It would be statistically impossible, effectively, for the same operator to end up with the only 3 instances where this has occurred, given the fleet historical data. That forms part of the evaluation exercise in my submission. And any proper evaluation exercise, bearing that in mind amongst everything else, affords, in my submission, of only one conclusion. You simply cannot eliminate insufficient hydraulic fluid as a cause of this loss. Even if it is this statistically impossible scenario, improbable, I say impossible scenario, namely that Bahamasair, for whatever reason, has suffered 3, for want of a better word, spontaneous instances of damage with no initiating event. That, in my submission, still does not establish negligence on the part of Messier Dowty, because it's not sufficient against that background to say it follows that it was negligent for Messier Dowty to produce this part, not when there's no reason to suppose that it would fail from normal usage, that the previous incidents disclose no reason to suppose that it would fail from normal usage, simply because there's never been an instance of the part failing in normal use in all the years of use worldwide. And it follows from that also that there's no liability for any failure to warn, because Messier Dowty, against that background, can't have known, and indeed it was not reasonable for them to know that this condition could exist, because none of the prior incidents involve such an event, and there is simply no evidential basis for Messier Dowty to even reasonably be aware that this part was prone, so long as it's owned by Bahamasair, no one else it would appear, to fail in normal usage.
Yes, well, thank you very much. I'm afraid your time is up.
Okay, I was going to deal very quickly with quantum, but I can leave that at what we say in our written case. It's a relatively simple point.
Thank you very much indeed. Mr. Akuni? Mrs. Rawl.
Obliged, my lords. Well, I think it's useful to start with Mr. Marlin's proposition that the initiating event must be the misuse of the component. In other words, there has to have been improper servicing leading to the violent contact between the seal carrier and the upper bearing, and then dislodgement of the damper ring by reason of the damage sustained to the upper bearing. Now, first of all, as Lord Justice Kerr would have pointed out, there was no suggestion of that case to any of the witnesses in the court below. And the request was made from a learned friend to find the reference where that suggestion was put to any witness, and up to now we haven't seen that reference because it never occurred. There was no such evidence, and there was no such suggestion. Indeed, what has been agreed from day one is that loss of damping results from an initiating event, that being either a broken damper ring, a disengaged damper ring, a missing damper ring, or improper servicing. Now, as a result, there is cumulative damage by reason of the existence of loss of damping, which causes further damage to the components, and that is what the evidence has been. And the first place that I think makes good that point is Messier's report itself. We didn't get the opportunity to look at DS 644. It is in volume 3, tab 26, and in the electronic bundle, it is 253. By way of summary...
Sorry, it's volume...
It's volume 3, tab 26.
Thank you.
And in the electronic, it is page 253. By way of brief summary, this
Sorry,
report...
you have to bear with me a moment. I have to follow this, and I can't find it for a minute.
So again, it's volume 3,
Yes,
tab 26.
thank you. Page?
It is page 232 that it starts,
Yes,
and it is a report of the respondent dated the 18th of December, 1996,
yes,
documenting 3, at least, cases, including Air Ontario. But what I want to refer to is page 235, or the internal numbering, the conclusion at paragraph 4. And there are two, the penultimate paragraph and the final paragraph, where it says, there has been one additional known instance of an upper bearing exhibiting cracking at the base of the lugs that retain the rebound ring. This rebound ring was being inspected as a part of a 20,000 cycle inspection report. There were no recorded discrepancies found on the rebound ring removed from the same shock strut. So I pause there to us to consider that paragraph. You're seeing fractures at the base of the lug, but at the point of examination, the rebound ring is still intact. Final paragraph. The initiating event: damaged lugs in the groove of the upper bearing, or broken or malfunctioning rebound ring, or impact damage to the upper bearing, or incorrect charging, cannot be determined from these observations. So, in their assessment, they're including as an initiating event, this is the respondent, damaged lugs, broken or malfunctioning rebound ring. So now, that of course is entirely consistent with the evidence of the appellant's experts, specifically Mr. Jones, who, during the course of his cross-examination, actually it was his examination in chief, made the point that in his opinion, the initiating event was fracture of these lugs. He specifically described them as fatigue fractures occurring in normal usage. And that evidence, I will just, in the interest of time, I will give the reference. In the hard bundle, it is 885, and this is the transcript. Sorry, in the hard bundle, it's 851, my apologies, and in the electronic bundle, it's 885. What you will see at those references, an exchange of evidence between the learned Chief Justice and Mr. Jones, where he's explaining, giving his opinion as to the mode of failure. And it is exactly consistent with what we just saw in DS 644, that being his view, that both from the design of the old upper bearing, remember you just have this 6 lugs as opposed to the continuous surface that you saw in the new bearing. He gave the opinion that the design, as well as the insufficient strength of the material, led to fatigue fractures at the base of the lugs. And over time of normal usage, normal contact between the upper bearing and the seal carrier, these fatigue fractures progress to the point where the lugs are broken. The damper wearing then disengages, loss of damping ensues, and as a result of now the violent contact, you have further damage to the components. So that is what the evidence was. And I think it would be remiss of me to point out that Mr. Jones said that, and whereas he was specifically asked by counsel for the respondent whether he had considered the possibility of improper servicing in the context of Bahamasair, he was never asked or was never suggested to him that the sequence of events that he described could only occur if there had first been either improper servicing or misuse of the components. So this is all something relatively new for the respondent in its case. And in those circumstances, it cannot be suggested that the learned Chief Justice was wrong to have considered something that was never a part of the evidence. Now, as it relates to Air Ontario and the suggestion that the only teachable moment from Air Ontario was the fact that you had a problem that emanated from excessive wear to the cylinder bore, I've already referred the board to Mr. Fisher's own contradiction of that notion. Because he said on 2 separate occasions, number one, that as a result of Air Ontario, he recognized, or the respondents recognized, that despite there being sufficient hydraulic fluid, there was still an over-center condition arising by virtue of damage to these components. My learned friend referred to Mr. Fisher's distinction about the word approximate. If you read on below that particular reference, you will see that I then engage him, and he confirms and he agrees that approximate is only in the context that there is normal seepage. But at no point was it suggested that that seepage was in any way material to his conclusions or to the position that he took in response to my questions. But in addition to what I've already referred the board to, I want to refer the board again to Mr. Fisher's own statement as to the respondent's learning as a result of the Air Ontario issue. So if you would go now to hard bundle 875, this is the transcript, and that would be electronic bundle 909. At page 875, it is line 24, where what's happening is I'm questioning and going through the process of comparing the findings, the damage on the parts of the subject landing gear, the left main landing gear, with what they found in Air Ontario. And I say to him at line 24 of page 875, now quite apart from the upper bearing being damaged, your investigation into Air Ontario found that all of the lugs or the airs or the scallops on the upper bearing were missing, correct? Mr. Fisher says, correct. I then say, correct me if I'm wrong. It is these lugs or airs or scallops that serve the purpose of holding this dampering in place, correct? Mr. Fisher says, correct. I then say, and in this case, coming back to Bahamasair and the left main landing gear collapse, the damage that you found also consisted of the lugs being missing. Mr. Fisher says, correct. Now, this is what is significant. Switching back to Air Ontario, isn't it true that a part of the result of your Air Ontario investigation was that the absence of those lugs contributed to the freeing or dislodgement of that dampering? Mr. Fisher said, correct. So, on more than one occasion, he acknowledged, in addition to what we've seen in DS 644, he acknowledged that the very pattern of failure that both of the appellant's experts, well, specifically Mr. Jones, identified as the initiating event was one of the conclusions emanating from the Air Ontario matter.
Yeah, but what's said against you is that what matters is what breaks the lugs. And what's said against you is that you have to have some entirely abnormal vibration, violent motion to cause that. Then they may go in any order.
And I understand that is what is being asserted at this point.
I'm subject to the point that it doesn't seem to have been put to anybody. That is not necessarily what he is saying here could still be consistent with that, couldn't it?
Well, the difficulty, I would say, is this. Number one, as I just indicated, DS 644 demonstrates the initiating event as being a fracture dampering.
Yeah.
It certainly does not say that this is the result of improper usage and then this sequence of events.
Well, is there actual evidence that, to the express effect, that this was the initiating event, the fracture of the lugs?
In the Bahamasair case?
Yes.
Absolutely. Those are the references that I referred you to Jones.
Yeah, well,
Jones, in fact, said that his analysis and his opinion was that both the design of the original upper bearing, with the load being spread across those 6 lugs as opposed to being continuous, and the material of the upper bearing, that being aluminum as opposed to the changed steel, contributed to fatigue fractures developing from normal contact over time. Not from violent contact, he said from normal contact over time.
That's in his report.
That's in his evidence.
Yes, well, it's in his report, certainly.
Yes, and it's also in evidence because he elaborated in his evidence in chief. He elaborated on how he arrived at those conclusions. So it was not just a design concern, it was also a materials concern, both of which were changed when the new bearing was implemented.
Could you just help me with the Air Ontario report at
That would be
235? And a paragraph which I don't think we looked at. It's talking about incorrect charging of the shock strut. What does that mean?
Well, there was never any evidence as to what that was.
Right. So, because there are 2 causes of high velocity impacting, which is the banging that
Correct.
we've been hearing about, as I've understood it. One is incorrect charging of the shock strut, and another is malfunctioning rebound ring,
Yes.
and that results from all the sorts of fracturing or damaging of the ring situation,
Yes.
and also the damaged upper bearing.
Yes, and I do think it's significant that they opine on the initiating event after noting the fact that in a separate case, quite apart from the cases that they were documenting, they saw this process where the rebound ring was still intact, but they're seeing the commencement of this process by the cracks at the base of the lugs. So that penultimate paragraph, that preceding paragraph, sets the context, we say, for what they ultimately said. And that's entirely consistent with what Jones said in his evidence, that this is the reason, this is what led to ultimately the loss of damping by virtue of the lugs coming off and the damper ring dislodging and fragmenting. You see, once loss of damping then commences, if you look, and you can see it in Aaron Hall's as well as David Jones's report, the progressive damage then on the upper bearing goes beyond the upper bearing groove, the damper ring groove, sorry. Because at that point, loss of damping has already started and the damage is now progressive. But as the initiating event, we say, and our witnesses said, of the fracture of these lugs that sets this process in motion. And we say that, given the fact that a contrary suggestion was never put to these witnesses, thereby left it entirely permissible for the learned Chief Justice to have made a finding, to have accepted Aaron Jones's evidence as he did. And when you go through the cross-examination, it was never suggested to Aaron Jones that there was any fallacy in his opinion or in his analysis. In fact, I will go so far as to say, when you look at the types of questions that were put to him, there almost seems to be agreement because the question was put to him as well as to David Hall, what goes first in your opinion? And he says, I truly believe, or I'm of the opinion that it is these lugs that break first, and then that causes the damper ring to be freed, and so forth and so on. So that type of questioning does not lend itself to a suggestion of a contrary case being put to the witness. When you read it, it appears as though the witness's testimony is being accepted. But even if you don't agree with that interpretation, certainly there is no challenge to it, and there was no contrary evidence adduced. And so in those circumstances, it was entirely permissible for the learned Chief Justice to have accepted it. Now, I think it's important for me to also make the point, because there is this suggestion that because of what Transport Canada ultimately did, the events that led up to DS 644 and 650 back in 1996 are not necessarily material. But one of the things that I want the board to be mindful of, the Airworthiness Directive in 2006 came about as a result of AOM 794, which was in 2005. And I want us to take a look at that briefly. AOM 794 is in volume 3, tab 42. So that's page 340 in the paper bundle, and 365 in the electronic. Now, very quickly, when you look at the reference, there are two issues that this AOM is addressing, AOM 794. A, task card 321015, which is the servicing issue. I'll repeat, AOM 794 is addressing two issues.
Yes.
When you look at A, you see that it's addressing task card 321015. That's the servicing task card, so it's the issue of servicing the landing gear. And B, the now well-known removal of the needle roller. So there are two issues that this is addressing. And it points out that investigation into these 6 incidences that they are referring in this AOM have revealed servicing issues. And as a result, task card 321015 had been implemented for the purposes of getting operators to focus on the problem, the specific problem of improper servicing. It's the penultimate paragraph then says, this issue, that is the servicing issue, has been discussed with Transport Canada, and it is expected that an airworthiness directive will be issued to mandate compliance with the service bulletin and the new MRB task, that is the servicing task card, service bulletin, compliance will be required within 3,000 flight hours. So essentially, this AOM addresses the servicing cause, improper servicing as an initiating event. And if you go to tabs 28 and 30 of that same volume, you see that in 2004 and in 2005, you had landing gear collapses in 2 different matters, one being the South African Airways case, the other being the Allegheny Air case. In both instances, 2004, 2005, the cause for loss of damping and the ultimate collapse was improper servicing. So you have this chronology of events with these incidences where improper servicing is the operative cause. You then have the task card in July of 2005. You then have AOM 794 in 2005 and the Airworthiness Directive in June of 2006. So you have these particular incidences of improper servicing sending the sequence of events, firstly to AOM 794 and then to the Airworthiness Directive, to address this issue of servicing that was clearly manifesting itself. And the point I would make in this respect is that the learned Chief Justice clearly recognized, after engaging with the witness, that this AOM 794 was addressed insofar as it relates to the subject aircraft, to servicing issues. And you will see his reference to that in the bundle, in his evidence. And it's at hard bundle 853, electronic bundle 887. And so I say that to say, my lords, that in 1996, 1997, you have Australian Air, Great China Airways, Air Ontario, you have DS644, you have DS650. There is no evidence of Transport Canada being aware of DS644 and DS650. So it could not be suggested that Transport Canada, certainly there was no evidence to demonstrate that Transport Canada was aware of what transpired as a result of those incidences, the investigations into those instances that led to DS644.
I'm sorry, I'm having difficulty hearing.
My apologies. I'm saying that there's no evidence to demonstrate, whereas we see the chronology of events as it relates to improper servicing after 2004, where Transport Canada issued the Airworthiness Directive as a result of AOM 794, which focused predominantly, well, exclusively, as it relates to this aircraft, on servicing issues.
But the 2006 directive wasn't limited to servicing issues, was it?
Well, it also dealt with the anti-rotating pin, which does not relate to this aircraft. So that's why I say, insofar as it relates to this aircraft, it was a servicing concern.
So it actually called for replacement at next overhaul?
Yes.
And you said that was because of the pin?
Because...
So it didn't apply to this aircraft at all?
Well, insofar as there's a servicing concern, because bear in mind now, if there is a loss of damping causing further damage to the components,
I see. So
you still would change. The Airworthiness Directive mandated that you change to the new part, which was more robust. But that direction, following on AOM 794, was because of this servicing issue emanating from the South African Airways and the Allegheny Airs incidents. But the point I was making was that there is no evidence of Transport Canada being aware of what transpired in 1996. And in any event, I think it's important, as it relates to the duties of the respondent, if you go back to Fisher's witness statement, it's paragraphs 94, he speaks of a very broad purpose of a service bulletin. If you take the respondent's position at its highest, and you say, well, the only purpose for this new part was because it was making it better, it's an improvement, which of course we do not accept, but let's assume that for a moment. Fisher himself says that the purpose of a service bulletin is to advise operators of a new part, a more robust part. I don't think that anybody could put forth an argument that the new bearing was more robust than the old. So Fisher acknowledges, the respondent acknowledges, that the purpose of a service bulletin also is to tell Bahamasair that, look, there is a new part that is applicable to your aircraft. But nowhere in the evidence, nowhere in these papers will you see a service bulletin having been issued, if only for that purpose. Or even to say, check your cylinder bore, because we feel that the problem is really with the cylinder bore. No warning about that either. And the bottom line is, when you look at Aaron Jones's evidence, he says that had they done that, even that, the incident would not have occurred, because with the more robust part, even with improper servicing, the accident would not have occurred. And I will give you the reference to that statement that Mr. Fisher made that was also unchallenged. That's right. So in terms of, with a view to wrapping up all of the other points.
You'll give us the reference to that, Mr. Jones?
I'm having somebody get it for me.
I mean, I know you're running out of time. Very quickly. Look, you've got 4 main landing gears on these two 501s. 3 of them proved to be defective. Mr. Marlin says, well, what's going on here in terms of servicing?
Yes. And
what do you say to that?
We say what's going on in terms of servicing is exactly what happened in 1996 with these other gear. The fact is, no in-service difficulty with any of those other cases. Everything is operating normally. And I'm just repeating what the report says. No indication of any problems. Air Ontario, you have the approximate or correct amount of fluid. But you go in there, and the dampering is completely destroyed. The upper bearing is completely destroyed, just like ours. And that, we say, is entirely consistent with what Mr. Jones has said. And if you look, I think, again, I should make the point that in this case, we're at the end of the cycles. The recommended cycle is 30,000. In our case, you're at 25,000. In DS 644, you notice that each one of those is at 25,000. So as you're approaching the end of the life of that part, it just does not make it to the point where they have recommended it would, or the point where they say you ought to change it, which is 30,000 cycles. And the evidence will demonstrate that Bahamasair, despite the assertion of sloppy maintenance, took it upon themselves to change it even earlier, at 27,000. So even with the 27,000 change, it would have been subsequent to the collapse. As it relates to all of Learned Friend's submissions as to improper maintenance, the reason why I started with showing the pleadings, there was a positive case of improper maintenance put forth in the court below by the respondent. The Learned Chief Justice, rightly or wrongly so, rejected that case. None of that was appealed in the court below. And these are issues, extension checks. He found that they were done. It's not open, we say, in the absence of an appeal in the court below, for the respondent to now challenge whether or not they were done. That point is now moot. The determination was made and it was not appealed. And that applies to everything else. Improper servicing, the notion that there was a failure to comply with the CMM, anything that formed a part of their contributory negligence plea, we say, a determination was made, it was not appealed, that's the end of it. As to the burden of proof, when you go to paragraph 52, you see that the Chief Justice clearly made his comments relative to the burden of proof as the culmination of his analysis and consideration of the respondent's case on contributory negligence. He was saying that this is what they have asserted by way of negligence, and they have failed to satisfy me to the standard. So there was no shifting of the burden. It was merely a culmination of his rejection of their case of contributory negligence. And I think everything else, my Lord, I note that I did address in my written case.
Good.
So I think that we're...
Thank you very much indeed. We're very grateful to counsel for the oral submissions and grateful also to those who contributed to the printed cases. The board will take time to consider what advice they will humbly tender to Her Majesty.
If I may pose a question.
We're going to finish at 4 o'clock. And
It's just as to what our obligations are, because the question was raised as to the provision of our skeleton arguments in the court below. And I just want to know whether we should comply with that.
yes, you can send those in.
I would.
My Lord, can I give you two...
Forgive me, there's a reference to Mr. Fisher that we're waiting for as well.
Yes, we're also waiting for...
Yes, if I can give you two very quick references. In relation to cross-examination of Mr. Jones about damage consequent on insufficient fluid, it's the hard copy transcript references are page 849 to 851 in bundle 5. And in relation to my Lady Black's question about charging, the document behind tab 59, amongst other places, I say indicate that charging is a reference to the nitrogen levels in the shock stroke. There's reference to the nitrogen charging kit.
Yes, thank you very much indeed. Now, the written submissions before the Court of Appeal should be provided to the registry within 1 week of today, and if you can also let us have that reference to Mr. Fisher's evidence, Mrs. Rowe.
Pardon me, sorry.
The reference that you weren't able to locate to Mr. Fisher's evidence. I know you have told us about paragraph 94 of Mr. Fisher, but I think there was another reference, wasn't there, that you were going to...
the purpose of the service bulletin.
Yes.
We can provide those.
Well, you can provide that also within a week. Yes. Thank you very much indeed.